Mr. Chairman,
Mr. Reed.
may I be heard on a procedural matter?
Yes, sir.
Thank you, Mr. Chairman. I wanted to alert the Commission that about an hour ago, Dominion Energy, on behalf of the joint applicants, filed the second supplemental rebuttal testimony of Dominion witness Prabir Pruitt. Mr. Pruitt's testimony outlines a revised customer benefits plan proposal, which we are calling Plan BL. Plan BL has been developed as a result of continued requests from commissioners and otherwise to help find a reasonable solution to the NND cost recovery issues presented in this case and respond to specific suggestions from policymakers that the temporary rate imposed under Act 258 is a basis for such a solution that is both reasonable and legally tested. Plan BL adopts the recommendation of the ORS to levelize the recovery of the allowable NND rate base, and by doing so, the typical residential bill will fall slightly below the temporary rate to a level of $125.26, inclusive of all tax benefits and amortization expense. The Plan BL net present value for customers is superior to either Plan A or Plan B, which were previously submitted, and will result in customers paying $130 million less in nominal dollars over time compared to Plan B. Mr. Pruitt, in his testimony, lays out the details of this plan and the resulting bill levels. He also, as ORS has requested, included a table in this testimony which sets out, in a summary form, the merger-related regulatory conditions that the joint applicants are currently willing to accept, including several conditions suggested by commissioners during the course of this evidentiary hearing. So, Mr. Chairman, I would ask at this time for leave from the Commission to recall Mr. Pruitt tomorrow in order to sponsor this testimony and to answer questions from the Commission or any of the parties. Thank you, Mr. Chairman, and I do have printed copies of the testimony available for the commissioners or any parties if they would desire them at this time.
Okay, yeah, we would like them, and it's granted. We'll hear from Mr. Pruitt.
Thank you, Mr. Chairman. We'll pass those out.
Hey, hang on, Mr. Balzer. Let him pass those out real quick, and then we'll continue. Okay, Mr. Balzer, if you may continue.
Thank you, Mr. Chairman, and I'm almost done. So a couple more exhibits and then we'll be finished. Ms. Walker, I want to direct your attention to a document that has been placed in front of you, or I hope it has. It is an email exchange dated November 19th, 2015. Do you have that document in front of you?
I don't think so.
Do you have it now, Ms. Walker?
I think so.
Thank you. On November 19th, Anne Marie Higgins wrote an email to Jimmy Addison that says, "Hi, Jimmy. Carlette, Kevin, and I just had a very good conversation. The most important thing for her health right now will be for Carlette to take some time off. We agreed that Carlette will be off next week with pay, and during her time off, she will determine how she can take some additional paid time off. During December, we were originally looking at the week of Christmas and the week of New Year's, since these are typically quiet times in the office anyway. Kevin has asked her to take full weeks to really get away rather than break it up into days. Carlette will look at the calendar to ensure someone can cover during the week she is out." Then Jimmy responds to Anne Marie with copies to you and Kevin saying, "I completely agree." And you send an email back to Jimmy with copies to Kevin Marsh and Carlette saying thank you for your support. You see that?
I do.
Mr. Chairman, I'd like to ask that this document be marked as the next hearing exhibit.
This will be entered as exhibit number 160.
Now, Ms. Walker, earlier this morning when you were in attendance in the gallery here, you saw Mr. Kokums on the witness stand, did you not?
I did.
And Mr. Kokums is a gentleman who worked for you, right?
He did.
And you don't view Mr. Kokums as part of the conspiracy that you've described, do you?
No, not at all.
Okay. Now, I want to direct your attention, Ms. Walker, to a document that we marked as exhibit number 25 in your deposition testimony. This is an email exchange between you and Mr. Kokums in the May 27th and May 28th, 2015 timeframe. The email starts at the bottom like all email strings do, with an email from you to several people, including Mr. Kokums, in which you say, good morning, and just wanted to let you know that Gene is making slow but positive progress, and you go on to describe how he's doing. And then Kevin Kokums responds, Carlette, I'm happy to hear Gene is improving. I'm certain that his progress and good spirits are a direct result of you being there with him. I wouldn't underestimate how much of an impact that can have. We got it here, so don't worry about work at all. It will be here when you get back. Then on the 28th, you respond at 11:33 a.m. Thanks, Kevin. I spoke with Mitch Monday evening, and he said you were doing an awesome job in carrying the ball on my testimony all weekend, including on Monday. I don't know how to express my gratitude. He said, Carlette, I'm glad I could help, as I know you would do the same thing for me. I just hope you're happy with how your testimony turned out. And you said to Mr. Kokums, I'm very happy with it, exclamation point, exclamation point, exclamation point, correct?
Yeah, just more evidence that Kevin wrote the testimony with Mitch, and my husband was in the hospital, probably had his second surgery at that point, and I'm expressing my happiness because I was able to rely on Kevin, not because I've read it, but I expect that Kevin would do a really good job on it.
Those are all the questions. Mr. Chairman, that's already in the record. Those are all the questions I have, Ms. Walker.
Thank you. Okay. Commissioners. Commissioner Williams.
Thank you, Mr. Chairman. Good afternoon, Mr. Brown and Ms. Walker.
Good afternoon.
Thank you for appearing today. I want to start off by saying this. We've been here for a while, and this hearing is as much about the decisions that the commission has to make regarding whether or not the prudency decision or whether it was prudent to abandon the plant, and whether the merger is in the best interest of South Carolina or the best interest of the ratepayers, or stated another way, doesn't provide any harm. As much as we have to make those two decisions, I think that the number of viewers we have on our live stream and the number of people that have been in tune with this hearing also support that the public trust is at issue here. There are a lot of interested parties regarding the public trust. And I will tell you as a new commissioner, but for the testimony of you two, I'm not sure if there would be any evidence of questionable decisions made by leaders within the company. I'm just going to state it that way, questionable decisions. And we've heard from both sides. I don't know if we've heard testimony as strong as the testimony we've heard today, but this hearing has been full of emotion and strong testimony. So with that being said, I just want to make sure I understand you all's testimony clearly, and make sure everyone here understands it clearly, and everyone that's listening in, that we really understand what you're saying. Now, to you, Mr. Brown, is it your testimony today that SC ENG, whether it was collectively or some individual, purposefully misrepresented the numbers that you presented to them regarding the cost to complete the nuclear plant and the time to complete the nuclear plant, the new nuclear plant, units 2 and 3.
Purposefully, with intention to, I'm not sure that I understand your question fully. If you could elaborate on your question.
Did they, with the intent to hide, if you will, the fact that the project could potentially cost a whole lot more and take a whole lot longer to complete than Westinghouse numbers presented? Did they purposely withhold that information from the ORS or from the commission? In your opinion?
In my opinion, there was a purpose. I'm not sure what that purpose was. That's what I don't really understand about your question.
Well, what was the purpose?
The purpose, as I understood it with regard to cost, was that under the previous rulings, the project could not have a contingency applied. And the feeling was that to go with a higher cost than what had been presented by the contractors would, in effect, be putting a contingency on the project. Now, I understand, and in fact, I've heard others' testimony because I've been watching in. It's a very difficult situation when you have a contractor that you're doing business with, and he comes in with what could be considered a lowball estimate. What do you do with that? I mean, I've heard two people address it, and both of those people had different answers. You know, one is, do you go back to the contractor and say, you're sure? Don't you want to raise your price? That's an unusual way of addressing a contractor. But, you know, I'm not sure. If I had been calling the shots and making the decisions, I believe it would have been more open to present the contractor's cost and present evidence of why I believe that cost was low, but I still would have filed for a lower cost, I believe. But you know, I think in full disclosure, somebody needed to know that we did not support that cost as being the most accurate estimate. Does that make sense?
It does, and I want to follow up my question with another. In your summary, you state that ORS is a responsible party or has some blame in this failure. Is that correct?
Yes.
Okay.
I believe that.
Why do you say that?
The consultant for the ORS represents himself as having 40-plus years of experience in the construction of nuclear power plants. Now, this is true. This is my first nuclear plant, and I had 10 years of experience on that, but I have experience in other construction projects, and it's my belief that the ORS consultant, if he had had my personality traits, okay, he would not have accepted the presentation that I gave him or the acceptance of problems, because Mr. Jones was aware of the problems. And I like to chase a problem to the end. Mr. Jones, in my opinion, and I'm guessing that's what you're asking for, Mr. Jones, in my opinion, he was willing to accept answers that I would not have accepted and move forward.
All right. This is my last question now, because It sounds like you, with all due respect to you and your testimony, sounds like you're talking out of both sides of your neck now. Now, on the one hand, you say he should not have accepted the presentation that you gave if he would have had your personality, right?
Right.
Essentially stating that you would not have accepted your own presentation.
I would have asked questions.
Here's my question to you. Why didn't you say something to him? Just make it plain. Why don't you tell him, hey, Mr. Jones, I've ran some numbers, and I think this is completely unachievable, or I don't know how you would phrase it, but you could say it's unachievable. The numbers are much lower than I think they should be, and the time to complete is much less than I think it should be. Weren't you in a position at the time to make that statement to him?
Not really. I was an employee, and somebody had made a decision over in a higher position than me. And as I stated in my summary statement, when somebody makes a decision that I'm working for, I believe that it's my job to either support their decision or find another job.
And is that why you resigned?
Not really, because at the time I resigned, we were past the period and the fixed price had been in place. I stayed on in that job because I wanted to make a difference. I saw where I was saving money for the project. As long as it was under the target price regime, and I'm not boasting, but I will tell you today that I saved the project hundreds of millions of dollars. And I saw that I was making that impact, and that's why I stayed. I left when I left for really 3 reasons. The number 1 reason is the fixed price was in place. The number 2 reason, somebody had come along to take my place that I felt like he was able to take over and do what needed to be done with the fixed price agreement in place. And number 3 was because I was able to. But it had any one of those 3 not been there, I think I would have stayed to make a difference where I could make a difference.
Thank you, sir. Ms. Walker, 2 things I want to sort of unpack with you. I think I understood in your in the cross-examination, I read some testimony on the screen here, and from what I remember, essentially in your deposition, one of your depositions, you stated that Dukes tore up a report and told someone not to testify about that report. Am I understanding that correctly?
The way I understood it was that Gary Jones had actually prepared testimony for the 2015 hearing, and that testimony never saw the day of light, or the light of day. And that testimony didn't support SCE&G's request.
No, why didn't it see the light of day?
As I understood it, it was shown to SCE&G's executives, and they discouraged SC or the ORS from using that.
And when you say that's the way you understood it, is that something that you saw with your own eyes?
No.
Is
That's why I used the word understood.
Okay. Is it something you heard with your own ears?
I heard of it.
You heard it while it was happening? Were you in the same room, or?
No,
or
I just heard of it. It was
heard of it. Okay, like a rumor or something like that.
Right.
Okay.
But I heard of it from multiple people.
Okay. All right.
And I know that Gary Jones was not at the hearing. And then after I had left the company and resigned, I happened to be flying home from Chicago, and Gary was in the O'Hare airport heading to Columbia for his monthly reviews or quarterly reviews. And what are the chances I happened to be getting on the same airplane as he was, and we ran into each other. And he didn't even know, this was like in July, he had not been told that I had resigned from the company. And so the company was misrepresenting that I had retired from the company. And I had to inform him that I didn't retire, I resigned. And he had made the comment, he said, well, I'm certain that Dukes would be very interested in knowing the reason why you left the company.
Mm-hmm. Okay. Now, would you agree that those of us who don't have your experience with this project and have not had to spend the time, effort, and energy going through the depositions and actually just living the life you had to live when you first started on the project up until this point, how we may have some questions about why you're coming forward now with these allegations. These are would you agree these are some pretty serious allegations that you're making? Allegations against Kevin Marsh and Jimmy Addison and all the other folks who, the way I understand your testimony, colluded to run you out of the company?
Yeah, they're serious allegations.
Okay.
And as far as the timing of when I'm bringing these forward, I wasn't the whistleblower on this particular case. We were able to work something out, and unfortunately, they breached that twice. I had actually gotten outside legal counsel, and we've agreed that because of the nature of what had happened at that project or what was going on at the project when I left the company, based on how I explained what was going on, that it wouldn't continue, and that just the natural course of what was going on at the project, it was going to fall apart and land in the ditch, and that the natural course would end up with it being before this commission and before the SEC and the FBI. And so rather than my having to be the whistleblower on this case, I would just go ahead and let it just take its natural course rather than me having to be in the midst of it.
Okay. Thank you for being here, folks.
Mr. Urban.
Thank you, Mr. Chairman. To follow up on that point, if you weren't the whistleblower in this case, who was?
I don't know. When the FBI showed up at my house unexpectedly, they made reference to having spoken with engineers, and they said everybody that they talked with, for whatever reason, my name continued to come up.
What engineers did they talk with?
They wouldn't share those names.
Who do you think they were?
I really don't have any idea. I mean, there were so many people on that project, whether it be, the people that worked for CB&I or Westinghouse or people that worked for SCENG that were on that project. It was obvious, I think, for most people that worked for the company that I was struggling with the project. I can tell you, I worked on that project for 6 years. The first 3 years, I didn't take any vacation. I left my house at 7 in the morning, and I normally got home between 8 and 8:30. It sucked the life out of me. The last 2 to 3 years, I was going to the doctor for trigger spots that were hitting me in the back. I had headaches out the wazoo. I'm seeing a neurologist about those. I had a heart attack in March of this year that the doctors confirmed that it was nothing but stress from the job. I mean, that job just about killed me. I've lost 80 pounds from that job, and that weight came off of me at the rate of 10 pounds at 2-week intervals from the time that we had that hearing in July until the second week in January of 16.
What do you think would be a fair and just result in this case, based on all that you know?
I think there are costs that were incurred by that company and charged to that work order that are imprudent.
What costs would those be?
Now with a look back after having seen what was negotiated in that fixed price contract, I would say at a minimum costs that were incurred after the March 2015 filing that SCENG filed with this commission to increase their budget.
Mr. Brown, was that what you were talking about earlier, when there's really no connection between the invoices being paid and the projected cost? Didn't you say that earlier, or words to that effect?
Yes, under the target price scenario, the owner was responsible for paying the bills that the contractor submitted. As long as they were valid bills, as long as the contractor had incurred the costs, then the owner had to pay those costs, whether it was within the estimated amount or not. If it was over the estimate.
We heard earlier testimony, one of the witnesses for the company, I believe, someone said, talked about phantom invoices. Did you hear that testimony?
I did not, but I know the term.
Tell me what that means.
The phantom invoices, gets back to when the fixed price agreement was negotiated, and we agreed to make the $100 million a month for 6 months.
Was that ever in writing?
Yes, it's incorporated in the agreement. And what happened was the contractors were to continue to submit invoices as they had been prior to the fixed price agreement.
Why was that?
So that in the end of the 6 months, we could take those actual invoices and true those up to the $600 million.
Which is why you asked for the true-up. You insisted on it.
That's correct.
But it never happened.
The true-up did not happen. And that was after I left, but I do understand that it did not happen.
And so, without the true-up, they were phantom invoices, in a sense.
The phantom invoices were the ones that were going to come in that would not be paid.
They would not be paid. Okay, all right.
They were phantom because they were going to be the same types of invoices that we had been getting for the previous period, but they would be used to true up against the $600 million. So if they had sent us phantom invoices for $500 million, then we would get a $100 million refund. And that never happened. In fact, I don't believe the consortium ever sent us the phantom invoices. We kept asking for the invoices while I was still there, and they never once sent in the phantom invoice. They didn't. They were right on time sending in the invoices for the $100 million, and we made those payments. But the phantom invoices never came in, and they never intended to do the true-up.
Mr. Urban, if I could
Yes, ma'am.
also share something with you. When prior to that fixed price contract, SCENG and Santee Cooper never incurred cost for craft labor anywhere close to $100 million. The most we ever paid out was in the neighborhood of $50 million in a month. And so that's when I knew for a fact that I was dealing with somebody who had crossed over the line and was lying. When they agreed to pay $100 million a month for the consortium or the new construction crowd that was going to be there, when they had no training, they were going to be new on the project, and you were going to suddenly start paying double the amount that you've ever paid.
Why did they agree to do that?
I think they were financing Westinghouse. I mean, the first 5 months was $500 million, and we had always heard that Westinghouse's cash flow needs for a year was $500 million. Just happened.
Do you think the company knew that Westinghouse was in financial difficulty?
Oh, absolutely.
And,
we all knew that.
And Mr. Brown, did you think that the fixed price contract would essentially be the beginning of the end for Westinghouse?
As I believe I stated in my summary, I knew that Westinghouse would not, or I believed very strongly, they would not finish the plant for what they had agreed to accept.
It just wasn't reasonable, was it?
Not reasonable.
And it wasn't. It was clear to you that it would never work.
That's right. Well, what was clear to me at that time was that Westinghouse and Toshiba wanted to get the AP1000 to the market. And we always, the terminology was a loss leader, or, you know, I used to always think about it as General Motors, when they come out with a new car model, the first car that rolls off the line, they don't make any money on. They have to sell some cars before they're making money. So the AP1000, I believed that Toshiba had the financial wherewithal to bring this to market. And their success in marketing nuclear power plants depended 100% on VC Summer and Vogel. And if those projects were not successful, it was the Edsel of power plants. They're not going to be able to sell them. So, and they told us that. I mean, it was not something that we dreamed up on our own. We were told that. We're willing to take a loss on these plants to bring the AP1000 to the world market. They were looking at selling, 15 or 20 units. And they should be able to make money on maybe not even on the 5th and 6th units, but somewhere down the line, the nth plant, they were projecting to make a profit and roll that back in to recover for the ones they lost money on.
But they needed financing. And I think SCANA stepped up to the plate and said, we'll do your financing, but we'll also roll it into rates, and we'll make money off of our ratepayers.
So the ultimate losses would be suffered by the ratepayers in this scheme.
Absolutely. And now, I mean, if that's, they lost on that, they had to shut down the project. And so, they're greedy. And so we're going to short the dividends to the stockholders. So we're going to go ahead and throw $110 million into a trust fund, irrevocable trust fund. So, our little greedy executives, we can still get our golden parachute. And to heck with the stockholders, we'll just cut their dividend by 80%. And so the poor people on fixed income that are looking for that dividend, well, too bad you can't eat and pay your power bill for the next 6 months because we're going to cut your dividend.
Mr. Brown, looking back, though, don't you think that project, it was in such difficulty early on that it should have been abandoned long before it was abandoned by the company?
I'm not sure that I would say that, no.
You really thought Westinghouse could finish it?
Yes. I knew there were schedule problems, and they may not qualify for production tax credits, but I honestly did believe the plants would be finished. And
you thought that Westinghouse would just absorb whatever billions of dollars it would take to finish it. They would finish it. Toshiba, you thought?
I didn't think that. They told us that.
Yeah.
Yes.
Did Toshiba tell you that as well? Or just Westinghouse?
Toshiba, I was not in any of the meetings with Toshiba, but I was in the meetings with Westinghouse where we were told that.
Thanks, sir.
Yes.
Commissioner Whitfield.
Thank you, Mr. Chairman. Thank you all for being here. Mr. Brown, certainly during your time with Santee Cooper, we wouldn't have ever heard from you, and I don't think we ever heard from you as an SCE&G employee, and we thank you for being here. And Ms. Walker, I was chairman in 2016. We had the fixed price option contract, and I believe I even asked where you were because I was used to you testifying and Mr. Torres and others who had been around since the inception of the project. And I'll borrow your words, but I do believe I was told that you retired and obviously weren't with the company anymore. I do believe I remember being told here when we started the proceeding that you had retired. But I want to get back to the matter at hand here. Would you agree, unfortunately, wherever the blame lies, this commission's still got to fix this problem?
Yeah.
And in that light, we've got to fix this for ratepayers and the citizens of South Carolina and for all South Carolinians going forward. And there aren't a lot of good options here. However, going back to some of your testimony that's been debated over and over today about the 2015 testimony for the 2015 case when you had to be out for your husband's illness. Certainly, it's obvious that that's been the subject of your testimony today, but up until that point, from the inception of the project, do you know of any other instances where your testimony, and you had testified several other times, or testimony of others might not have been exactly what we thought it was as we did in 2015? Now, certainly we were told about the module problems and the problems at Lake Charles. Those problems had been moved to on-site work here at Jenkinsville and also up into Virginia. I think some of those modules, that work was relocated there. But are you aware of any other mischaracterization or misrepresentation prior to that, the 2015 case?
The only thing that I know of as it relates to nuclear, I think that Ken I know Ken would be better able to address it, and that related to the initial decision as to what fuel would be the best base load fuel to go back to, and that related to owner's cost. And I think this was something that was probably hidden from Bill Timmerman, who was the then CEO, and I'll ask that Ken explain to you what Ron Clary did with owner's cost to drive out his preferred choice.
I believe that issue was covered in my deposition, and I think what she's talking about is when we were first investigating the different technologies, we had the AP1000 from Westinghouse, the EPR from Areva, and General Electric. We were looking at the ASBWR and the...
And you said you were involved early on.
Yes, sir.
Yes, sir. Okay, go ahead.
I was with Santee Cooper then.
Right.
But in looking at all of those options, we contacted the companies, that's Westinghouse, General Electric, and Areva, and we asked them to tell us a number of things that would go into a cost evaluation. And among those things was the plant staffing that would be required. That's the operations and maintenance staff for the units. And at the same time we were doing that, well, actually, I was not doing it. I was watching it, and SCE&G was doing it. But the SCE&G folks in NND went to Unit 1 people and said, okay, how many people do you need and they had all the departments listed out. How many people do you need in each one of these departments to run 2 AP1000s or 1 EPR, it's a larger plant, or 2 ESBWRs? And so the people in VC Summer Unit 1 came back with a number of a head count, if you would, to operate and maintain those units. Well, we also got numbers from the suppliers, and the Westinghouse number was substantially lower for the AP1000 than actually for any of the other units or from what we got from Unit 1. So Mr. Clary, and we brought the issue up. I challenged Ron Clary with that. And he went back to Westinghouse and said, are you sure this is all you need to operate and maintain these units? And they said, yes, because of the design of the plant, the more modern controls, your outages are going to be shorter. You don't need as many people. So that head count was put into the original owner's cost. And it was lower than what we had gotten from Unit 1 for 2 AP1000s.
All of that was done prior to the original baseload review case in 08, is what you're describing.
Yes.
I guess.
Yes.
All right. Well, you've answered that. Going forward from that point,
Right.
Case that was held in late 2008. I think it was order number 2009-104A. From that order forward till the 2015 case, are either one of you aware of any other
I'm certainly not.
material facts omitted, misrepresented, or anything?
No, sir.
All right. Thank you.
And there is that one thing that's in my summary, and that would be the research and development tax credits that have been taken to the stockholders that I think, and I push to have those credited to the work order. And I think that y'all could easily order that those dollar amounts be credited to the work order and removed from the profits of the company.
I think you said a number in here.
Well, I put tens of millions, but I don't know the amount. I mean, it could be 30 million, it could be 75 million. They did it at the statute of limitations and went back and amended the tax returns as far back as they could, and then they probably claimed those since as long as the construction was going on.
Well, Ms. Walker, let me ask you one more question. And as you know, in this forum, we have to go by the evidence and the testimony before us. And we can't get into rumor and innuendo, although it's come out a little bit in this case a couple of times already.
Right.
And you just made another statement I think in your answer to Commissioner Irvin about craft labor going up to $100 million, I think you said, and you had never paid that much prior to the fixed-priced option contract.
Right.
Are you alleging there were any kind of abuses out there, such as unwarranted overtime, people sleeping on the third shift? We heard about the theft of the office furniture, but that apparently in the grand scheme of things, a lot of money to me, but a small amount in the grand scheme of things. Do you know of anything, any other abuses, if you will, that caused that number to shoot up that you just cited to Commissioner Irvin?
No, I mean, the $100 million is simply an amount that Kevin Marsh agreed to pay. There was no basis for it. And then as far as the amounts that we were billed based on actual timesheets, I do know that there were people that were not productive on the site.
Well, that's where I'm going.
That happened. And I talked to one of my auditors, an employee on my team, after I'd left the company, and I asked her, I said, did you in fact see people that were in connexes doing nothing? And she told me, she said, well, yes. And I said, why did you not tell me? I said, how many times did I tell the team I wanted to know if anybody saw people in connexes, because I did not want that to happen under my watch. And she said, well, Carlette, we knew Alan Torres wouldn't do anything about it. And I said, I don't care about what Alan Torres would do. Why didn't you tell me? Because I would have done something about it. But I think their point was that because the upstream work or materials weren't available, there were craft people that were sitting with nothing to do because they hired them anticipating that the work would flow and be on the job site. So I think that may partly be the nature of a construction project, but then part of it is the lack of management oversight at the project and the lack of accountability that the project management personnel provided to the project. I mean, you could go to the monthly project review meeting, and I'm an accountant, and I was more upset and more frustrated and uptight than anybody else in the room, and I was the accountant. I was asking questions that were way outside of my realm of expertise because everything was so out of whack.
And I realize you're an accountant. I realize that. But what you're saying here is the work, and there's a difference, we'd agree, there's a difference between waiting on materials and just outright loafing. But the PF that's been discussed in here, productivity factor, is a matter of large debate in this case, would you not say?
I mean, I think it's just like the absolute indicator of whether the job is getting done or not.
Well, how much oversight do you feel that SCE&G and or ORS or anybody else would have had, or control that they would have had over that productivity factor? Obviously, company wasn't hitting it, and there was this kind of hope that it would be hit, and
there was nobody that would even ask a question about the PF except me. I ask about the PF factor every single month in the monthly project review meeting, and every month Ron Jones, the VP of construction for the project, would hold up his hand and cut me off and tell me, Carlette, this is not the forum to ask that question, and I would get cut off.
Were either Mr. Jones or Mr. Torres or other engineers or supervisors ever questioned, or did they ever explain that productivity factor, or where they
Never.
What was going to be done
Never.
to mitigate or correct?
Never. That was one of my issues whenever I was reprimanded about when I had that personnel matter, and the HR executive VP took me in a room with my CFO, and they reprimanded me for going over their head to Kevin Marsh to have it their cut of the pay for the employee appealed. They took me in an office, and they had gone and sought out input from other executives to include CB&I's executive. And they read me the riot act and said that I was condescending in my comments. I called people names in meetings. Well, all I did was ask questions about the PF factor in hopes of trying to hold somebody accountable and try to drive out change to improve the PF factor. And then in return, I'm told that I'm using condescending language or tones in meetings.
Last question, Ms. Walker. Did you think, now that you mentioned CB&I, we were all aware of their exit, of course, up here, and a lot of things have been said about them truly not really being in the nuclear construction building, more into building components, forgings and the such. But did you think that when CB&I exited the project, did you think a lot of these problems would go away? Or were you hopeful that they would go away? What were your thoughts? Or I guess that was about the time you were leaving too, maybe.
Well, they actually were, I mean, I was involved with Ken and a couple others trying to do the calculations, you know, in the background of the negotiations. And I thought it was ludicrous to bring somebody else in because nobody had been in nuclear construction in 30 years. So, I mean, what's the difference between CB&I or the local guy up the street? I mean, it's like, I mean, you're going to vendors all over the world that are new to nuclear construction because nobody's built anything nuclear in 30 years.
Well, I asked you that question because Mr. Brown sounded like he was optimistic when CB&I exited the project and Fluor was brought on. Did you not share that optimism that Mr. Brown shared?
I mean, maybe we could have been optimistic. I don't have enough experience in construction to know whether Flora was a little bit better of a outfit than CB&I. I mean, CB&I was pretty terrible, but I had no experience with Flora. Ken may have had some experience that would give him some sense of optimism, but by that point in the project, I didn't have any hope for the project.
Well, thank you for your answer. I realize that's probably a little bit out of your purview with him being the engineer and you being the accounting, but thank you for your answers, both of you, and that's all I have, Mr. Chairman.
Thank you. Commissioner Elam.
Good afternoon. I also want to thank both of y'all for being here, Mr. Brown, Ms. Walker. I guess it dates us both to know that I remember you testifying for South Carolina Pipeline. A long time ago. And I always thought you did a very good job at that.
Thank you.
Mr. Brown, you started discussing with Commissioner Whitfield Ron Clary's feasibility study. 06-07.
Yes.
And that it basically, that it cut the cost of ownership in half?
It was the owner's cost portion of the contract. I don't know that it was half, but it was, I'd be afraid to say how much it was. It was a reduction in owner's costs, but his basis for that was Westinghouse. I mean, Ron Clary did not come up with those numbers. He was trusting Westinghouse. And nobody had built or operated an AP1000, so they didn't really know.
And you were using those owner's costs to compare perhaps what you would have in owner's costs with something like a combined cycle gas or just a different type of generation?
As a total, the generation planning people would take the total cost of O&M, and that goes into the there's owner's cost for construction, which is a capital cost, and your staff goes into that, the number. And then when you're operating the plant, you have an O&M cost that is also based on how many people it takes to run the plant.
Okay. Familiar with maybe the testimony of Dr. Lynch in these proceedings that he's testified about the feasibility of nuclear versus gas or coal in all the N&D proceedings?
Right.
What was Ron Clary's connection to Joseph Lynch's team and the numbers testified to by Joseph Lynch?
The numbers came from N&D to Dr. Lynch.
Okay. Were you told specifically what Ron Clary manipulated in his study to make nuclear more attractive cost for ownership costs, or is it?
I don't believe Ron Clary manipulated anything.
He just accepted what Westinghouse gave him.
Yes.
Even though perhaps he couldn't quite believe it.
Well, I think he believed it.
Okay.
I mean, I believed it also. I was here. I was sitting in the chair next to Ron Clary.
The perfectionist was the optimist?
I just accepted their
Okay.
response.
Now, Ms. Walker, in your deposition, you state that you were able to retain the work papers you used to determine the N&D project budget and schedule overruns. Is that correct?
Yes.
The Jimmy Addison file?
Yeah, I've got the Jimmy Addison file.
And I guess counsel can maybe help me out at whether this is part of the record or not.
Yes, Commissioner Elam, it's Exhibit 32 to Ms. Walker's deposition.
Okay. Did you simply use historical factors to determine your projections, or did you also include future assumptions in your analysis?
No, we didn't use any future assumptions.
What variables could have caused your projections to be inaccurate?
I mean, every one of the assumptions that we used could create a difference, in the bottom line number. I mean, we used averages for the craft labor pay. I mean, we used an assumption for the indirect tack-on charge. I mean, we did use the markups right out of the contract, so I don't expect that would create an issue. We used the budget to go as far as the number of labor hours. So primarily it would be the PF, and then perhaps the hourly rate for the craft personnel. Those would be the two biggest ones that would drive out a different answer.
Okay, and you felt reasonably confident in your assumptions?
I did. I mean, Ken was actually the one that was making the assumptions, and what I tried to do was stay out of their hair, but go over they were actually sequestered in a separate building that wasn't in use, and I tried to go over there once or twice a week and stay plugged in, and I mean, I thought everything that they were doing and all the assumptions that they made were very reasonable.
And ultimately, were they closer than Westinghouse?
Oh, absolutely. I mean, they were still short, but Westinghouse was a third of the actual, whereas Ken was maybe a third short. Westinghouse was 2/3 short.
Thank you.
Sure.
Commissioner Hamilton,
Thank you, Mr. Chairman. I wanted to personally thank.
make sure you get in front of that microphone, Mr. Commissioner Hamilton.
I want to thank both of you for being here, and I appreciate your testimony. At this time of the afternoon, we about run out of questions, but one thing that's still lingering in my mind from the testimony is the ESC committee seemed to have done an excellent job of predicting what was going to happen and what it was going to cost. Do either one of you have any idea why the results were not taken into consideration by the executive members of the company?
I wouldn't go there.
You wouldn't go there?
No, sir.
I have a suspicion, but I mean, it's just my thoughts. I mean, it's not backed up by fact.
Okay. Well, that'll remain a surprise, won't it, when we find out? Thank
I don't know that you'll ever find out.
you. Okay, thank you.
Commissioner Howard.
Good afternoon. Good seeing you again, Ms. Walker.
Good afternoon.
Brown. Oaks Corner, myself, with that in common. Ms. Brown, we discussed that upper management, but basically Marsh and Addison, did not use your EAC number than our testimony does.
Yes. Yes, sir.
By hiding that information, are they in violating of some laws with SEC or anything like that, in your opinion?
With SEC, sir?
SEC in particular, by not hiding, by not coming forth with numbers done internally by your organization.
Potentially. I don't want to go there. I'm not a lawyer. I'm certainly not an SEC specialist. And, I mean, their filing was based on a different number, so anything with the SEC would have had to have been the same.
Mr. Walker, any comment?
Let me just say that in December of 15, I purposefully took one of my CPE classes on business law, and the trainer of that class was an attorney from Colorado, and during each of the breaks, I had conversations with him, and by the end of the day, I was convinced that I probably needed to leave the organization.
Yeah, thank you for answering my question. One of you and I read both your testimonies, deposition together, but one of you went on a great deal about the drug testing problem. Which one was that?
That would have been me, and that was...
How big a problem is it? I mean, would the lack of labor because of failing drug tests in the site, could that affect the performances?
It could affect the ability to hire qualified people. Fitness for duty is the term that's used. And before somebody shows up to work on really any industrial site, but certainly a nuclear site, they have to be fit for duty. And I'm not sure of the exact ratio, but it was a fairly high percentage of people that were not passing the drug test when they show up for employment. And that was one of the reasons given by the contractors as not being able to hire, a sufficient quantity of craft.
The disputed invoices, I think you said you all met quarterly on that?
We got an invoice every month, and as I reviewed the invoices, I would pull out the issues that I felt were not properly charged, and some of those were clear. There'd be no dispute. The accountants at CB&I or Shaw, whichever at the time, would immediately credit us for those. There were other issues that we may not agree on. I might have one opinion, and the accountant for CB&I or Shaw has another opinion, and so those items would go onto a log that was maintained, just a list, and there was a quarterly meeting between usually Alan Torres and the site manager for Shaw or CB&I, and they would go down that list to settle the disputes that were on that log.
Thank you very much. Appreciate it.
Commissioners, Commissioner Williams.
Commissioner Whitfield asked you all about prudency, and I just wanted to make sure before we let you all leave that I get a good understanding of your testimony. Now, Mr. Brown, you believe that it was prudent to abandon the development, right? The new nuclear development?
Yes.
Okay. How far back do you think cost disallowance should go? Are you in agreement with the ORS plan?
I'm not totally sure what their plan is, to tell you the truth.
Okay. Well, if you're not familiar with it, then that's fine. What about you, Ms. Walker?
I'm not familiar. I don't know how far back or where their cutoff is either.
Well, I heard you say something about March 2015, I believe, or 2016. Do you think all costs incurred were prudent up until that point?
Till March of 2015?
Yes, ma'am.
I don't have any reason to believe they weren't. I mean, I think that up until that point, I think that everything was they were being forthright. I think it was in March of 2015. I think that they knew that they were selecting the Westinghouse because that was palatable for the commissioners. I think that they were scared if they came forward with $1.2 billion that might scare y'all.
Mr. Brown, do you have any comment on that?
Not really, no.
Thank you, folks.
Mm-hmm. Thank you.
Commissioner Irvin.
I wanted to thank both of you as well for coming to testify today. Based on what you've gone through and your life experience with this case, do you think that the public in South Carolina would be served if we had, like many other states, jurisdictions around the country, if we had our own Whistleblowers Act? Do you think there'd be any merit to that? You ever thought about that based on your personal experience? Some states have them where they're provided certain protections if they want to come forward and expose allegations of fraud or misconduct?
I'm just not familiar.
Not familiar with it?
to
Okay,
know-
no problem.
Yeah.
Thank you.
Commissioners, anything else? Mr. Cox, any redirect?
No redirect, Mr. Chairman. We'd ask that these witnesses be excused.
Ms. Walker and Mr. Brown, thank you for being here this afternoon or this morning or all day. And we appreciate your testimony, and you may be excused.
Thank you. Thank you.
Okay, seems we left off, we had Rose Jackson on the stand.
Mr. Chairman, you are correct. We did have Ms. Jackson up there. So we'll ask that Ms. Jackson come up here to the table and take her seat again.
Ms. Jackson, we apologize for rousting you out a while ago, but seemed to be that was the best timing.
Would you please state your full name for the record?
My name is Rose Moore Jackson.
And by whom are you employed and in what capacity?
I'm employed by Scanna Services Incorporated as the General Manager of Supply and Asset Management.
And have you prepared or caused to be prepared under your direct supervision and pre-filed in this docket settlement testimony consisting of 7 pages?
Yes, sir.
Do you have any changes or corrections required of your settlement testimony?
No, sir.
If I ask you all the questions contained in your testimony, would your answers be the same?
Yes, sir, they would.
Mr. Chairman, at this time we move into the record the pre-filed settlement testimony of Rose Jackson in the consolidated dockets as if given orally from the stand.
Okay, the pre-filed settlement testimony of Rose Jackson will be entered into the record as though given orally from the stand.
And Ms. Jackson, am I correct? You do not have any exhibits that were attached to your settlement testimony?
No, sir, I do not.
Okay, have you prepared a summary of your settlement testimony?
Yes, sir, I have.
Would you please deliver it at this time?
Good afternoon, Chairman Randall and members of the Commission. Before I read my summary, I would like to express my gratitude for you granting my date certain for my testimony today. It was requested due to a death in my family, so thank you. The purpose of my settlement testimony is to respond to the direct testimony of Mr. Hector Altori on behalf of Transco and to discuss the settlement agreement between Transco, SC, and Dominion Energy. Mr. Altori's concerns about the proposed business combination are unfounded and ignore the benefits of the proposed combination. His recommendations are also inappropriate and duplicative of the requirements regarding affiliate transactions and the company's fuel purchasing practices and policies. Regarding ACP rates, Mr. Altori fails to take into account that ACP is a new greenfield capacity and he does not consider supply cost and other important factors. Notwithstanding these concerns, SCE&G, Dominion Energy, and Transco entered into a settlement agreement which, among other things, provides the company will issue requests for proposals for capacity of 100,000 decatherms per day or more, will file confidential reports on such solicitations with the Commission, and will not contract for such capacity unless the interstate pipeline is the least cost provider or the Commission approves the contract. In the context of resolving these issues, the company believes the proposed settlement agreement is fair and reasonable and should be approved by the Commission. This concludes my summary.
Thank you, Ms. Jackson. Please answer any questions that the other parties have, as well as any questions by the commissioners.
Okay, we'll go to cross. Mr. Guile.
No questions, Mr. Chairman. Thank you.
Okay. Mr. Cleveland.
Could I have the Elmo, please? Hello, Ms. Jackson. My name is Will Cleveland. I'm an attorney representing the Coastal Conservation League and the Southern Alliance for Clean Energy. Thank you for being here. I'm sorry about the death in your family.
Thank you.
And I probably the only person who's going to ask you questions. I will try to make this as quick as possible so you can get out of here, especially since you've been waiting here all day. I appreciate that, too. I really just have some questions about the settlement agreement that you were just talking about, if that's all right. Sure. I'm not sure whose this is. Ms. Jackson, this is the settlement agreement, isn't it? Is it not?
Yes, sir.
Okay. Am I right that paragraph 1 prevents the company from signing any new contracts without first going through the request for proposal process?
The formal RFP process, yes, sir.
And am I right that paragraph 2 says that once they've gone through that process, the company can sign a new contract if, 1, the contract is least cost pursuant to that RFP, or 2, it gets other approval from this commission?
Yes, sir.
Okay. Were you here yesterday when Mr. Alatorre testified?
I was not, but I did watch it on live stream.
Okay. He testified that Transco and SC&G currently have a number of different contracts. Is that correct?
Yes, sir, that is correct.
Okay, this is HA1 from his testimony. And this was, I believe, all of the contracts between the two companies. Are you familiar with these contracts?
Yes, sir, I am.
Okay. He testified that, or seemed concerned that some of these contracts might not get renewed. I've highlighted both the commencement date and the expiration dates. Do you have any reason to think that those dates are incorrect?
No, sir, and I want to clarify one comment that Mr. Lander made regarding my testimony. What I think is laughable is that Transco actually tried to compare their existing maximum recourse rate, which is roughly 44 cents, to the maximum recourse rate that was filed in ACP, which is roughly $1.73, because Mr. Alatorre stated yesterday that they are fully subscribed, which means they have no capacity available on their system. And in the event we were to go to them for additional capacity, they would have to build new greenfield pipe. So that is laughable to compare their maximum recourse rate to any other, a legacy pipeline to any new project. So with regard to this capacity, there is no way that I would come before this commission or tell the ratepayers that I have been serving for over 25 years that I would select capacity that would replace this legacy capacity and cost so much more money. We have renewed these contracts time and time again, and the latest Transco piece of capacity we picked up for, we had to bid over 52 years as a term to get that capacity release.
Okay, I haven't asked a question yet. When you said 52 years, is that the 2084 contract?
Yes, sir.
Okay. I did ask a question, actually. My question was, are the commencement dates and expiration dates on this chart accurate as far as you know?
Yes, as far as I know.
Okay. Am I right that of all the ones that I've highlighted, there are only 3, which are the ones right here that I've flagged in red, that expire fewer than 5 years out? So you've got the 2084 and 2031 and 2029, but the rest, the expiration date is all within the next 5 years?
Yes, sir, and that's because Transco just filed a rate case, so we're in the process of negotiating that rate case.
Okay. Computers are unreliable. Here's a question about the settlement that is not clear to me. These are contracts that are already active. If the company wants to renew these contracts, does it still have to go through the RFP process, or can it renew them without that RFP process?
Well, it states that we shall not contract with an interstate pipeline for natural gas transmission capacity of 100,000 decatherms per day or more. So depending on which contract expires and that volume, that would be dependent upon whether or not we would issue an RFP. I will tell you that while we don't have a formal RFP because we have such a limited number of pipeline providers that we deal with, we are constantly in discussions with those pipeline providers, and we meet with any new pipeline providers that are working on projects so that they are aware of what our demand forecast looks like on an annual basis, because our goal is to participate in a larger project. We know that as some of our contracts are coming up for renewal or as our demand grows, that we can't go out to a pipeline on an annual basis and pick up that capacity to match one for one. So in order to gain economies of scale, we try to participate in larger projects.
Okay, and thank you for that. So it is possible that at least for some of those Transco projects or contracts, you can renew them without going through the formal RFP process and the settlement agreement.
Yes, sir. But once again, that legacy capacity is going to be so much lower than any greenfield capacity.
I appreciate that. Thank you. So let's assume that the company does extend and renew all three of those or all of those Transco contracts. The company, there's nothing in the settlement agreement that prevents the company from then going out and doing another RFP, is there?
I'm sorry, I don't understand your question.
Sure. To the extent that Transco is concerned that their contracts might get renewed, you just testified that it's possible that they could get renewed. In fact, they may get renewed without going through the RFP process. So let's assume they are renewed, all of them. There's nothing that prevents the company under this settlement agreement from doing an RFP after renewing all of the Transco contracts, is there?
That's correct. And this commission will have the opportunity on an annual basis to review all of the capacity and supply that we acquire and we purchase for that review period, which is a 12-month period. For the electric generation side of the house, we have an annual fuel proceeding. And for the local distribution company, we have an annual purchase gas adjustment proceeding.
Okay, thank you. So under the settlement agreement, does this commission have any oversight of the terms of that RFP process?
We would prepare the RFP and we would work in conjunction with ORS, and then as part of our annual reviews and the confidential filings with the commission, we would reveal that RFP. It's an industry standard RFP. Basically what it would state would be the timeline that we needed capacity, the amount of capacity, and the locations of where we could possibly receive that capacity.
Does the commission approve the screening criteria for that RFP?
They could do so as part of those annual reviews, I would assume.
But don't those annual reviews happen after the contract is signed?
Yes, and the company takes the risk of disallowance.
Okay. So my question is, maybe I wasn't clear, and if I wasn't, I apologize. My question is, before the contract is signed, does the commission approve the RFP terms?
We haven't been through this process yet, so as we stated, we're willing to do this.
Okay, so
part of a settlement.
Okay, so the company would be willing to have the commission pre-approve the RFP terms?
I don't see why not. I mean, the commission could, we could share that with the commission. Okay. And we stated we're willing to share that with these confidential reports.
And I understand the confidentiality piece. I'm not arguing with that. Would the company be willing to have the commission pre-approve the screening criteria?
Mr. Chairman, I would object to this line of questioning. Mr. Cleveland is trying to inject terms into the settlement agreement that's already been agreed upon by the parties, and I would ask that this objection be sustained.
Mr. Chairman, if I may respond. I was not trying to inject terms into the settlement agreement. I'm trying to understand what the terms of the settlement agreement are as Ms. Jackson is testifying since she's here to propose a settlement.
Mr. Chairman, he was specifically trying to get her to agree that this commission approve the RFP process before the company moves forward with this. So he absolutely is trying to do that.
Okay. I'm going to overrule, but get it to explain, and we're not going to inject anything that we're going to be doing.
Thank you, Mr. Chairman. And Mr. Burge, you're right. That last question I asked, I did ask if the company would be willing to concede that. So I agree with you on that last question, but only because the witness opened up the door to that. And I'll move on. Ms. Jackson, does the settlement agreement as it's currently written have anything to do with when the company issues that RFP?
In the event that we are going to be contracting for 100,000 decatherms per day or more of capacity. That is the when.
Okay. But in terms of when let's say the company identifies a need for 100,000 decatherms of capacity or more, the company can issue that RFP whenever it wants, right? It doesn't need to come to this commission first to ask permission to issue that RFP.
Well, we have to come once again before the commission on an annual basis and demonstrate that we have sufficient capacity now and in the upcoming review period to serve our customers. We are the supplier of last resort, and we take great pride in serving our customers reliably. And we're very blessed to live in a state where we now have 3% growth on our system.
I don't disagree with any of that. My question was, though, does the settlement agreement allow this commission to determine whether or when the company issues that RFP?
The settlement agreement will work in tandem with our existing procedures and processes that we have here at the Commission.
And it's assuming, and I believe you said that the company will issue the RFP, that the when trigger is if the company identifies a need for 100,000 decatherms or more. Is that correct?
Yes, sir.
Okay. Does the Commission have any oversight of how the company identifies that need?
Once again, we file on an annual basis what our existing reserve margins and our demand forecast is for this review period and for the upcoming review period.
What's the upcoming review period? How long is that?
It's a 12-month period.
Okay. So if the company identifies a need 24 months from now, that won't be in the upcoming review period.
We're now, because of interventions such as yours in FERC-related cases, instead of it being a 3-year process at FERC, we're now estimating that timeline could be 5 to 6 years. So when I come before not just the Commission, but when we have ongoing discussions with ORS on their annual audits, we are now looking out 10 and 15 years because that's how long we're concerned it's going to take before new capacity can be built.
You said interventions such as mine. What do you mean by that?
The client that you represent. When you look at some of the interventions that you have that you've represented your client at FERC and at other jurisdictions, that adds to the cost and the timeline of these projects.
Are you talking about the Coastal Conservation League and the Southern Alliance for Clean Energy? Or are you talking about some other client that I may have represented as a lawyer?
Oh, those two would be plenty.
Just wasn't sure which ones you were talking about.
I'm not aware of you having any more clients. Sorry.
I do.
Sorry, I just don't know.
No, that's fair. And my clients may regret the fact that I am their lawyer at times. There's no question about that. You talked about a needs analysis for new pipeline capacity. Are you familiar with that FERC process that you just mentioned?
Yes, sir, I am.
Okay. Are you aware of how FERC scrutinizes the alleged need for pipeline shippers who are sorry, let me start that over because it's a little bit of a sticky issue. When a pipeline developer such as the Atlantic Coast Pipeline seeks permission from FERC to build that pipeline, are you familiar with that process?
Yes, sir.
Are you aware that Atlantic Coast Pipeline presents to FERC that they have multiple contracts for that capacity on that pipeline?
Or precedent agreements.
Precedent agreements. You aware of that?
Yes, sir.
Do you have any idea how much or whether FERC scrutinizes the individual contracts that they receive?
They evaluate and look at each individual precedent agreement, but then they're looking at the project in totality. But I will tell you that my experience in the natural gas industry also includes being an affiliate of an interstate pipeline. When SCANA owned CGT at the time, Carolina Gas Transmission, there are also FERC rules that govern the relationship between affiliates called the Standards of Conduct. And I will tell you, as a marketing function employee or someone who's out in the marketplace acquiring capacity and dealing with my affiliate interstate pipeline, we often said it was reverse discrimination because parties that were not affiliated with our pipeline could get more information than we could as an affiliate. I often found out about new opportunities through other counterparties in the industry or within South Carolina before I could find out from our affiliate. So there are very specific requirements related to the standards of conduct and not being able to strategize, not being able to work on projects like that. So I know that FERC, in the proceeding for each individual pipeline project, they're looking at the totality of PA volumes, but they're also, when you look in terms of how do they see self-dealing going on, they regulate that very stringently.
Okay. Are you familiar with the August 10th, 2018 FERC order on rehearing regarding the Atlantic Coast Pipeline?
I'm aware of it.
Okay.
I can't say I remember the details.
This is page 19 of that order. And the highlighted portion says, we disagree and affirm the certificate's order.
Chairman, I would object to this line of questioning. I think we covered this with another witness, and Ms. Jackson does not work for Dominion. She's not involved with ACP, and I would ask that this line of questioning be sustained and objected to.
Sustained.
Mr. Chairman, this order is from FERC regarding the Atlantic Coast Pipeline. I will refrain from asking more questions. I would ask that the Commission take judicial notice of this order, since I have talked about it with some of the other witnesses. I don't believe I ever moved it into the record, but I would ask that order
We'll take judicial notice. Thank you.
And with that, Ms. Jackson, I have no further questions. Thank you.
Thank you.
Thank you. Any other cross? Can you give us a more exact cite for the order?
Mr. Chairman, I'd be more than happy to email or file the entire thing. I don't have a full copy with me because it's 180 pages long.
Okay.
Trying to save some trees.
Let's do that. Thank you.
Thank you, Your Honor.
Okay. Any other cross? Commissioners? Any redirect?
No redirect, and we would ask that Ms. Jackson be excused.
Ms. Jackson, thank you for your testimony, and we're sorry for your loss, and you are excused.
Thank you.
Sorry.
Okay. Can we get back to Mr. Young and Mr. Kokums? They keep reappearing. This is kind of like the Hotel California. Or maybe more like a Roach Motel. It's check in, but you never check out. I'm also keeping on getting my description of a few questions redefined every few minutes. So, Mr. Cox.
Thank you, Mr. Chairman. Mr. Kokums, before we adjourned, I had left a copy of Hearing Exhibit 31 on your table. Do you have a copy of that?
Is it this one?
No, it's the sensitivity analysis you performed in October 2015. That's it. That's the one.
Yeah.
That's Hearing Exhibit 31. There's a cover email to it as well, Mr. Kokums, so I'm going to put that on the Elmo. So, Mr. Kokums, is it correct to say that this is a sensitivity analysis that you performed in October 2015, evaluating the difference in cost between the current EPC contract and a move to the fixed price option under a couple different productivity scenarios?
Yeah, that's a fair representation of it.
And you mentioned under the current past scenarios, you actually had 3 scenarios here. Is that correct?
That's correct.
And you said the best case scenario was keeping the same substantial completion dates that were on file with the 2015 modification docket. Is that correct?
Yeah, the best case scenario was the June 19 and June 20 dates.
And on that scenario, you also used a productivity factor or PF factor of 1.75. Is that correct?
That appears to be correct, yes.
And you said that that's a reasonable driver, assuming that the consortium improves their performance. Is that correct?
Yes, that's correct.
So is it correct to say that at this point in time, a 1.75 PF the consortium would have needed to improve to get to that PF?
I think that's fair. I don't recall exactly where the 1.75 came from. I can assume that it was the current productivity factor, maybe inception to date. But I don't recall sitting here today where the 1.75 came from.
But at the time, you had the opinion that the consortium would need to improve their performance to hit that number, right?
Well, yeah, that's what we had indicated there, that there would be some level of improvement to sustain a 1.75.
And this is a higher productivity factor or worse productivity than the 1.55 scenario that you had done in February of 2015 that we looked up earlier. Is that correct?
Yeah, so there were different analysis that we did, different set of assumptions, different time frame. We knew different information when we did this one versus the last one. So yeah, the fundamental assumptions were different between the the earlier one and this one here.
Right. And so in October 2014, in that presentation that the EAC team made to senior management, the EAC team projected a 1.4 PF. Then you ran scenarios several months later with a 1.55 PF, and now in October 2015, you're evaluating a scenario of a 1.75 PF. Is that correct?
That is correct, yes.
And the other two scenarios on this spreadsheet involve a 6-month delay in completion to December 2019 and December 2020 that included a 2.0 PF. And the last scenario you evaluated was a 12-month delay to June 2020 and June 2021, and with that scenario involving a 2.25 PF. Is that correct?
Say that one more time. I want to make sure I got
Sure. In addition to this best case scenario that is included in this sensitivity analysis, the other two paths that you identified, the first one included a 6-month delay to the substantial completion dates, to the dates December 2019, December 2020, with that path involving a 2.0 PF. And then the final scenario you looked at was a 12-month delay in substantial completion dates to June 2020 and 21, with that scenario involving a 2.25 PF.
Yeah, that is what's represented on this sheet. At the time when we were evaluating the fixed price option, we did a lot. I'll represent a lot of different scenarios. So what we demonstrated here and in this email was, I guess I would put a worst case scenario of a 12-month delay and an almost absurd productivity factor of a 2.25 for the remainder of the project.
And it's correct to say that some of the monthly PFs fell above that 2.25 absurd productivity factor. Is that correct?
Well, if you look at just a month in isolation, that probably is correct, but 2.25 for the remainder of the project, including the increased productivity that we had been experienced with Unit 3, would kind of seem to be a guardrail or an outer bounds, yes.
Isn't it true that in November 2016, on that discovery response that we looked at earlier, that the cumulative PF to that date was over 2.0?
Yeah, up to that date, yes. But again, I think one of the fundamental assumptions was that there would be some level of improvement when Unit 3 work started to pick up.
And that never occurred?
Well, I don't know that we got too far into the Unit 3 work before we abandoned the project.
So it didn't occur, is that fair to say?
That's fair, yes.
Okay. And you never evaluated on this, at least in this email, a scenario with a delay in completion greater than 12 months. Is that correct?
I don't recall if we did an additional delay scenario or not. We may have. I just don't recall.
And you weren't informed of the Bechtel Corporation's assessment of the schedule that was revealed in October 2015 of an approximate 24-month delay, correct?
I did not know Bechtel's assessment, no.
And you didn't learn about that till after abandonment, correct?
That's correct.
And like Mr. Addison and Dr. Lynch, you were also a witness in the 2016 docket before this commission. Is that correct?
That is correct.
I'd like to look at the spreadsheet accompanying this email, specifically the worst case scenario that you kind of described. I'd like to look at the difference in cost between the current contract and the fixed price contract under that scenario.
Okay.
So can you go ahead and, Mr. Kogums, I know that folks have been talking about your spreadsheet for the last week or so. Can you walk through what the inputs are on that 12-month delay to come up with that cost?
I'll try. It's been 3 years since I've looked at this, but I'll certainly do my best. I think the intent of this evaluation was to compare the fixed price option to different inputs, changing assumptions, obviously a delay. So I guess I'm going to jump to the bottom of it. The number at the bottom of the page, that's a to-go number that should be compared to the to-go ultimate fixed price that we got from the consortium at 100%.
And is it fair to say that you calculated that the move to the fixed price contract, assuming a 12-month delay and a 2.25 PF factor, that there would be a net gain in cost or a reduced cost of $1.9 billion to the owners?
1.9 billion. Yeah, that's fair. Yes.
Almost 1.9, 1.889.
Right.
And included in that factor, you have a line here, and I'll point to it on the ELMO. You've got a line here that includes a $1 billion recovery of disputed cost under the current contract, and you're assuming what? Can you explain what this line represents?
So again, this was done at the beginning of October, and what we were trying to account for there was the open commercial disputes that we had with the consortium. Where that ultimately landed was that $250 million payment that we made that was included in the fixed price option. So at this time, we obviously didn't know that, but by the time we got to the executed October amendment, that line basically is moot.
Okay, and well, what you're saying though with this line, is it fair to say that if you had stayed on the current contract and there was an assumption of a 2.25 PF, that there would be approximately $2 billion of disputed costs between the owners and the consortium due to the decreased productivity? Is that fair to say?
That's fair, yes. That was.
And here you're saying let's ballpark it, assume that there's a 50% recovery of that amount, and you're subtracting $1 billion from the cost there, assuming that the owners would get about $1 billion in recovery in that dispute. Is that fair to say?
That would be fair to say, but again, with the fixed price option, that the dispute wouldn't exist.
But the reason you were using it is to see, okay, how much benefit is it to move to the fixed price option? And you had to, as part of that, you had to figure out, well, how much are we going to actually recover? Or you had to do an assumption about how much we would recover on this disputed cost under the current contract, correct?
Well, again, that line was intended to represent that if we had not settled the open disputes and obviously not assigned a fixed price option, if we did take those disputes to litigation, what would be the financial implications of that?
Okay.
And we assumed we'd settle at 50-50.
Now, if you had assumed that you would recover zero in that dispute, then would you agree that this line in your spreadsheet would now go to zero, and that course involving a 2.25 PF under the current contract, that cost would be $1 billion greater to the owners?
Well, again, if you remove that line from the spreadsheet, yes, it would go to zero, and the cost would increase $1 billion. Yeah.
And that would create about a $2.9 billion difference between the fixed price option and the current contract under those assumptions, correct?
Given all those assumptions, yeah, that would be the 100% impact.
Now, we talked about this earlier, but under the current 2008 or the original 2008 EPC contract, the owners had to pay 90% of the disputed invoices. Like Mr. Brown testified earlier, if the invoices for actual work that was done, the owners had to pay 90% of those, even if the owners felt that they would dispute that payment as the consortium not being entitled to it due to the low productivity. Is that correct?
Well, again, there were two options available to us within the EPC contract. One of them was to pay the 90% and withhold the 10% if the invoice was invoiced properly. If we determined that it was not invoiced properly, we returned the whole thing and we didn't pay any of it.
Okay. So if the invoice was for a cost that was actually incurred by the consortium and the owners were billed for it, you would still pay 90% of that invoice, even if you thought that the consortium wasn't entitled to recovery due to low productivity.
Sometimes, yes. Sometimes we took a liberal interpretation of that not invoiced properly stance, and we didn't pay any of it.
Okay. And now, looking at this line item on the 12-month delay, 2.25 PF, that involves about $2 billion in litigation costs. If you had paid 90% of that $2 billion, do you agree that would be about, the owners would be paying about $1.8 billion for that amount in dispute?
Yeah, I mean, I'm assuming your math is right there, but yeah, if we had a $2 billion dispute, we only paid 90% of it. Yeah, that's correct.
And so let's assume the owners did that before any litigation. Then the reduction on this line would only be for $200 million, not for $1 billion. Is that correct?
Following that logic and that set of assumptions, that is correct. But again, once we signed the fixed price option, we didn't have a dispute on labor productivity anymore.
Okay, and I'm just comparing the benefit of the current path to the fixed price option. Mm-hmm. And just following this logic through, you have a difference of about $1.9 billion between the current path and the fixed price option under this 12-month delay scenario, and that's with a 50% recovery of disputed cost. Before litigation, if you had paid 90% of those invoices, the difference would be even greater than that $1.8 billion. Is that correct?
Well, that'd be a timing issue. I mean, if we ultimately we would pay the 90% and it would be settled in the dispute, either by the dispute resolution board or by taking it to litigation. So there would be a timing issue there.
Okay, but until litigation, until the owners recovered any funds in litigation, the cost would be greater than prior to that. Isn't that correct?
That is correct, and I believe there was some clause in the EPC contract that said if costs or if items went to this dispute and were settled, that there be some form of interest paid on those costs as well.
Okay.
So theoretically, we would, if we did pay the 90%, we got that back, we'd get that amount back with some interest.
And this sensitivity analysis that you ran, if you had ran a scenario with a PF of 2.25 and a delay of 24 months in completion, that would have resulted in even a greater difference in cost between the current contract and the fixed price option. Is that correct?
Yeah, the price would have went up if you increased the PF or added a delay. That's correct.
And is it correct that despite the fact that you determined that there could be about almost a $2 billion net loss to Westinghouse in the contract shift to the fixed price option, you were never asked to run any analysis on the bankruptcy risk to Westinghouse in October 2015?
I was never asked to run an analysis on Westinghouse, but they wouldn't have asked me. They would have asked somebody most likely in our credit department to do that.
And you've heard the testimony about these fixed $100 million a month payments after the fixed price option was put into effect. Didn't you, Mr. Kokums?
Yes, sir.
And I think you talked about that in your 2016 testimony to the commission, and I want to briefly look at that. I have a copy for you. So this is from page 876 of your testimony in the 2016 docket, Mr. Kokums, and I've flagged it for you. It's at the bottom of page 876. You're being questioned by Commissioner Howard, and the question is, good morning, Mr. Kokums. In your direct testimony, you stated the fixed price option would be 3.345, and that was June 30th of 15. How much has been paid and credited since June 30th of 15 presently? Answer, that's a good question. If I could speak in 100% numbers, I can probably get us closer to that. I believe between June of 2015 and December of 2015, we had paid roughly at 100%, about $350 million of that. And since January of 2016 to date, we've paid, I think, a little bit over $1 billion. So rough order of magnitude, 100% number would be about 1.4 or 1.3 billion. Question, do you think that remaining balance you have left is sufficient to cover the price of the contract? Answer, well, that's certainly the amount that Westinghouse has committed to, so yes. Now, when you were answering the Commissioner's last question there, you were referring to the commitment that Westinghouse made to fulfill the fixed price option. Is that right?
That's correct.
You weren't referring to whether you thought the project would actually cost the amount of the fixed price option.
No, I was referring to the contract we had with Westinghouse at that time.
And is it correct that if you do the math on those rates about what was paid in 2015, between June of 15 and December of 15, you said that about $350 million had been paid during that 6 months. That's roughly $58 million a month. Is that correct?
That seems about correct, yes.
And then if you look at the 2016, between January to September, having paid about $1 billion, that's over $100 million a month, correct?
That's right. I think I was referring to the $100 million payments we made during that period.
And is it correct that if the total value of the fixed price option was 3.345 and the owners had paid about 1.3 or 1.4 billion already at the time of the 2016 docket, that the owners had paid roughly about 40% of the amount committed under the fixed price option already by the date of that hearing?
No. So the 3.345 number, that's SC&G's 55%. The numbers I was referring to on page 877, I gave 100% numbers. So you'd have to take 55% of the 1.3 or 1.4 billion.
Okay. And then do the math into the 3.345 to determine how much has been paid on the contract today.
Yes, sir.
Was there a plan for the consortium to ramp up spending after the fixed price option was enacted while Fluor was coming on board?
That was my understanding, was that Fluor was going to come on board and ramp up. I guess to me that meant hiring more direct craft. So yes, there was some indication that they were going to ramp up.
And did that ever occur?
I don't know if it did or not.
Mr. Young, do you know if that occurred?
Yes, it occurred. It also occurred off-site. There were a lot of expenditures off-site. So for the 2014 and 2015 period, prior to what we're talking about, there were a lot of disputes between Westinghouse and CB&I at vendors like Newport News Industries that was making shield building panels and a lot of other module manufacturers, along with commodity vendors. And those vendors needed to be paid so that work could move forward and progress. And there was a large procurement expenditure required of Westinghouse to right the issues that were stacking up at vendors.
Did the consortium provide actual invoices for the costs that were incurred in 2016 to the owners?
No, not on fixed price items, not on items that had been previously fixed or firm price under the old contract terms. So my understanding was under these parallel invoices, as it was called in the amendment, that they were billing based on milestones that were in the previous arrangement. So we would not see, nor had the consortium or Westinghouse ever taken a position, we were allowed to see the commercial terms they had with vendors because it was all fixed or firm price.
What about for the invoices for items that used to be Target under the previous contract and were now fixed under the amendment? Were the owners provided invoices of the actual cost for those items?
I can't say firsthand, but my understanding is that eventually, and Mr. Kokums may be able to confirm, eventually we saw the floor labor invoice once the Westinghouse incurred that, and that would have been equivalent to the CB&I target labor invoice.
Is that correct, Mr. Kokums?
That is correct. So the October amendment called for 5 $100 million payments while we negotiated the construction milestone payment schedule. We realized that was a pretty significant undertaking, and we needed time to do it. So during that 5 months, we received phantom, or what we call parallel invoices, based on the old contract terms. We didn't pay those invoices, but we got them so that we could calculate the true-up. I think you heard some discussion about that a little bit earlier. By the time we got to the May-June timeframe, we had about a $66 million credit that we felt we were owed, which essentially meant after 6 months that under the terms of the old contract, they had billed us $66 million less than the $100 million payments.
And is it correct that those interim payments of $100 million a month occurred even after those first 5 were made because a construction milestone agreement had not been put into place?
That is correct. After the April-May timeframe, we deferred that to the Dispute Resolution Board, and that process took several months to get through. And during that time, the DRB had indicated that we should continue making those lump sum payments.
And you're saying that the DRB directed the owners to do that?
That was my understanding, yes.
Where did you get that understanding?
I guess it would be somebody from our legal group.
Okay. And last issue, Mr. Kokums, you did an analysis, or you were part of a team that did an analysis in 2017 to determine the cost to complete construction after the Westinghouse bankruptcy, correct?
That is correct.
And you determined that the likely cost to complete construction would be far greater than what Westinghouse had included in its estimate, correct?
Again, I think that's the 2017 EAC process Mr. Young described earlier this morning. And yes, we did reach a conclusion that the cost would be increased from what was previously approved by this commission.
And how much was the increase that you calculated?
I don't recall. I know we did several different presentations, assuming completion of both units, assuming completion of only one unit. I don't know where those numbers ended up off the top of my head.
So the Westinghouse calculation was only for completion of both units, correct?
That is correct.
And is it fair to say that the calculation that SC&G did to determine completion of both units in 2017 involved an estimate of more than $2 billion greater than what Westinghouse had calculated?
I don't recall if it was $2 billion or more or not.
Was it more than $1 billion?
Again, I don't remember what that number was off the top of my head. I'm sorry.
Okay, no problem. Thank you, Mr. Kokums and Mr. Young. No further questions, Mr. Chairman.
Thank you. Other questions? Mr. Elliott.
Questions are for you, Mr. Kokums. Drawing your attention to the October 27, 2015 EPC amendment. You recall that, don't you, sir?
Sir.
And my question is, CB&I was released of all liability under their contract by virtue of that amendment, weren't they?
Yeah, that's my understanding.
And CB&I, while they were part of the consortium, had a parental guarantee for payment of some amount under the contract, didn't they?
Yes, that's correct.
And I asked Mr. Winnick, who advised y'all to execute that contract, what that parental guarantee was and what amount was the guarantee, and he couldn't remember. Do you remember, sir?
I don't remember a number, no, sir.
You think anybody at SC&G remembers how much money they let go out the door by virtue of the release of CB&I under that agreement?
I guess I wouldn't phrase it that way. I don't know that any money left because CB&I was removed from the consortium. Toshiba actually assumed CB&I's liability, so any amount of money that CB&I would have paid was paid by Toshiba.
Now, Can you say that, Mr. Kokums, when you can't tell me exactly the amount of the parental guarantee under CB&I?
Objection, Mr. Chairman. Mr. Kokums has clearly answered the question. The question doesn't need to be answered again.
Sustained.
You don't know what the CB&I guarantee was, do you, sir?
Same objection, Mr. Chairman.
Sustained.
Now, under the EPC amendment of October 27, 2015, there was no milestone schedule agreed to. Isn't that correct?
That is correct. We had agreed to develop a construction milestone payment schedule, but the schedule itself was not documented in the October amendment, no.
And you've testified to the fact that under the EPC amendment, the company was to pay $1 million a month until a milestone schedule could be agreed upon. Isn't that correct?
It was the 100% number was $100 million, yes.
All right. And it was anticipated that it would take about 5 or 6 months for the parties to enter into a milestone schedule agreement. Isn't that correct?
That is correct, yes.
And if the parties could not enter into an agreement for the milestone schedule, this dispute resolution board would be convened and it would mediate or arbitrate a resolution of that issue, correct?
That is correct. I'm not sure if mediate or arbitrate is the right legal term, but yeah, they would make the decision.
And I'm not sure it is either, but as I understood it, the decision of the dispute resolution board would be binding for the purposes of the construction contract, but that an aggrieved party could deal with, could make a claim against the other for any disputed amount after the project was complete. Isn't that correct?
That's my understanding, is that anything we took to the dispute resolution board, and there was a limit on it. It may have been anything over $5 million, where we could live by the ruling of the DRB, but at the end of the project we could go back and litigate it.
And as I understand it from your deposition, the owners had to make 11 $1 million payments before the milestone schedule was actually agreed upon. Is that a fair statement?
Yeah, there were 10 or 11 $100 million payments that we made.
All right. Well, 10 $100 million payments would be $1 billion.
Correct. At 100%, yes, sir.
All right. And so the owners disputed some of these $1 million payments that they made, did they not?
I'm sorry, disputed the 100. Could you say that one more time?
Well, you didn't spend. While you spent $100 million during the period per month, Westinghouse could not justify $100 million in progress, could they?
So Westinghouse didn't have to justify to us how much money they spent. What they did need to provide to us was how much they could have billed us under the old terms of the EPC contract.
Very fine. And those amounts were under $100 million per month, were they not?
So by the time we got to the May-June time frame, that was the $66 million that was below the $100 million.
All right. And so and the DRB ruled that you must go ahead and pay the $66 million, correct?
They ruled that a true-up wasn't necessary, so we had already paid it, so we weren't paying it again.
And if you had the opportunity to dispute the $66 million upon the completion of the construction of the units, you were unable to do so by virtue of Westinghouse's bankruptcy. Isn't that so?
Sure, yes.
And so that $66 million claim was discharged in the Westinghouse bankruptcy, correct?
Yeah, my understanding is Westinghouse rejected our contract.
Now, I want to draw your attention, if I may, to the Westinghouse bankruptcy, and you testified just at the conclusion of cross for Mr. Cox that that the company that you were on a team, that EAC team that developed a construction schedule to complete the two plants. Did you testify to that?
Yes, sir.
All right. And as I understand your testimony, the owners and Westinghouse entered into an agreement immediately prior to the filing of bankruptcy, wherein Westinghouse would continue to continue to construct the plants for certain payments during bankruptcy. Isn't that correct?
That is correct. Prior to actually Westinghouse declaring bankruptcy, they came to us and provided what they thought their estimate to complete was going to be. We did an evaluation of that and determined that the parental guarantees we were going to get from Toshiba were pretty much going to cover all of that costs. So we made the decision to enter into the IIA, the Interim Assessment Agreement, while we could perform a more detailed evaluation of those costs and schedule.
As I understand it, the interim assessment agreement had to be approved by the bankruptcy court?
I don't know if it was or not. I'm sorry.
But the interim assessment agreement was not approved by this commission, correct?
Again, I don't know if it was or not.
And how much per month or per week did the owners pay Westinghouse under this IA interim assessment agreement?
So it varied. On average, I would say at 100%, it was probably about $20 million a week.
All right, $20 million a week, that would be $80 million roughly a month, correct?
Correct.
And as I understand it, y'all entered that agreement late March. Let's call it April Fool's Day. So you entered into April, and when did you terminate construction with Westinghouse?
I believe that I went through August 7th.
All right, so I hadn't prepared the math because I wasn't sure what the answer was, but that would be April, May, June, July. That would be 4 months and a week into August, and so that would be about 17 months times $20 million a week.
Yes, I think in total the total amount was around $400 million, and what we're doing, we're actually currently evaluating that right now to compare that $400 million against actual invoices that Westinghouse had received and processed during that period. And if that number turns out to be that they paid less than $400 million, we expect to receive those funds back from Westinghouse.
And the conclusion of the EAC in this event was to abandon the construction of the plants, correct?
That was the ultimate decision made by the company, yes.
And so in essence, the ratepayers are being asked to pay the owners $400 million to do an assessment of the project schedule for the plants. Isn't that true?
Well, again, when we received the initial information from Westinghouse, the data they provided us had indicated that the cost to complete would be covered by the Toshiba parental guarantee.
And so the EAC that determined to abandon the plants was a much more expensive EAC than the one that Mr. Brown testified to, isn't it?
I'm not sure what you mean by much more expensive EAC.
You ended up paying at the end of the project, 9 years after the project, $400 million to get a correct schedule. Isn't that the case?
I don't know that I would characterize it that way, but.
No further questions.
Thank you. Any other questions? Yes, ma'am. Before we get to anything else, too, we're going to lose Mr. Butler at 4:30. Mr. Menges is going to take his place. If there's anything you need the hearing officer for, nobody else is leaving till we're done. But just wanted to make sure. Okay.
Thank you. I should be quick. Mr. Cocombs, my name is Carmen Thomas, and I'm a lawyer for Santee Cooper, the South Carolina Public Service Authority. Do you have your exhibit KRK1 in front of you?
I do.
As I understand it, this exhibit is the updated schedule of costs for the new nuclear project through December 31st, 2017. Is that right?
That is correct.
And these are all the costs incurred by SCE&G related to the project, excluding transmission-related costs and any other costs of items that are already placed in service, right?
Yeah, these are SCE&G's costs, yes.
Right. And that means that that's 55% of the capital cost of the project, unless otherwise stated. Is that right?
That is correct.
Which corresponds to SCE&G's ownership share of 55%, correct?
That is correct. There were some costs that were not shared with Santee Cooper, so it rounds to 55%. Though.
Okay. So Santee Cooper's portion of that then would be the 45%, other than some of the costs you just mentioned.
For the EPC portion, that is
Right.
probably true. Now, I'm not aware of what Santee Cooper's owners' costs were
Right.
or their AFUDC, so I certainly couldn't speak to those.
But as to the numbers that are on this chart, this is the capital cost, excluding the things that I just mentioned, the transmission costs and the items that are already placed in service.
Yeah, these are SC&G's costs, yes.
Right. So the 45% of the costs that are on that chart are the responsibility of Santee Cooper. Is that right?
Again, you could probably do that math with the EPC costs, but again, I don't have any insight into what Santee Cooper's owner's cost or AFUDC was.
Right, and I want to exclude those things from what I'm asking and exclude AFUDC that's on this chart. So let's look specifically at excuse me, on the bottom right, the $4.645 billion. Is that the non-transmission related total actually spent by SCE&G?
Including AFUDC, yes.
Right. So then the highlighted number over here, does that exclude the AFUDC?
That does, yes.
Okay. And that's 55% of the SCE&G non-transmission related NND project costs, excluding AFUDC.
Yes, that is SCE&G's portion.
SCE&G, and that also excludes the owner's cost, right?
No, owner's cost is included in there.
And what item is that?
It's the line named owner's cost, the $409 million.
All right. So excluding that $409,000 there, what is the total minus owner's cost for SCE&G?
I don't know that I could do that math. It's $409 million, and that's in 2007 dollars.
Right.
So some of that line that is labeled total project escalation, that $387 million, some of that is for owner's cost, and some of it is for EPC costs. I just don't have that breakdown.
So that 409, though, is not a substantial portion of the $4.472 billion.
It's certainly a lot of money. I'm not sure if
Proportionally, though, to the $4.472 billion.
it's 10%, I guess.
Okay. So about 55% of the of that number is about 55% of a total number, though. Is that correct?
That is about 55%, yes.
And what do you know what that total number is?
Not off the top of my head, I'm sorry.
Well, subject to checking my math, I think that it's $8.131 billion. Would you agree with that? Subject to checking.
Which number are you taking? I'm sorry.
The $4.472 billion.
Okay, and you're just dividing that by 0.55?
That's right.
Yeah, I would.
Subject to checking.
Subject to checking, yes.
So that's 8.131. And then that means that if I took 45% of that number, that'd be approximately what Santee Cooper's costs, excluding AFUDC, and then taking out the portion that's the owner's costs there that are only to SCE&G. Is that correct?
And you would need to add Santee Cooper's owner's costs?
Right, but just assuming that we're not talking about Santee Cooper's owner's costs for now.
That's approximately probably right, yes.
Okay, and that'd give us about $3.6 billion, 45% of that number.
I'll trust your math.
Thank you. That's all I have.
Thank you, ma'am. Any other questions? Commissioners? Any redirect?
Very briefly, Mr. Chairman. If the chairman wasn't enough to make clear I needed to make this brief, Mr. Balser told me the same thing, so I'm going to go as fast as I can here. My questions are for you, Mr. Cocombs. You were in the room earlier, and we heard some testimony in these proceedings that you were involved in helping draft Ms. Carlette Walker's 2015 testimony submitted to the PSC. Is that right?
That is correct.
Okay. During the time that this testimony was being prepared and following its submission to the Public Service Commission, did Ms. Walker ever tell you that she was unable to review the testimony before it was provided to the Commission?
No, she didn't.
Did she ever tell you that there was something in her 2015 testimony that she did not agree with?
No, she never did.
Okay. Now, I want to go to the $100 million payments issue very, very briefly. You were asked about the $100 million payments that the owners made to Westinghouse beginning in January of 2016. What's your understanding of the purpose for those payments?
The purpose of those payments was to allow us time to properly develop a construction milestone payment schedule.
Okay. Did you understand that amount, the $100 million amount, to be an approximation of what Westinghouse was expecting to spend on a monthly basis?
That's what they had represented to us. We had looked at it, and they were spending probably close to $80 to $90 million a month.
Okay. Now, was that $100 million actually included in the rate base?
No, it was not. So the $66 million I referred to before, which was the what we thought was going to be the true-up, we actually had that in the work order as a credit. So when we filed for revised rates in 2016, that actually decreased the amount we asked for. So we did not ask for that in rates.
Okay, that's all I have, Mr. Chairman. Thank you.
Any recross? Okay, gentlemen, thank you for your testimony. You are excused. Okay, now we're going to take a break for lunch and come back tomorrow at 9 o'clock. Yes, sir.
Mr. Chairman, just on a point of order, we're working on the late filed exhibit that Commissioner Elam had requested. Mr. Rooks will not be with us tomorrow due to travel arrangements, but fear not, we have a Dominion witness who will be able to pick up the baton and move forward.
Thank you.
And
yes, sir.
Just for planning purposes, Mr. Chairman, with your indulgence, I think the only two witnesses left are Mr. Pruitt and Mr. Byrne. We would propose to put Mr. Pruitt up first and then finish up with Mr. Byrne.
Okay. That's the way we'll do. Okay. Anything else? We're adjourned.